Okay, so as many of you may recall from earlier in the semester, John Locke talked about 3 natural rights, which were life, liberty, and property. Now, in our founding documents, we talk about life, liberty, and right. So, which of those is not guaranteed? Property. Which is why decisions like Kelo v. New London are all the more appalling. As you may or may not recall, Kelo v. New London basically cleared the way for the government to use the takings clause in the 5th Amendment to justify basically anything as long as it was for some specific public purpose as opposed to public use. It's one thing if the government seizes your weirdo like farm out in Wyoming so that they can make a national park. I mean, that makes sense. But it's another thing if they're just like, oh, this area needs economic revitalization. Let's build a quick shop. Here, give us your home. It's kind of important, it's kind of scary, so those are some things you might want to know. As for why it's the most important Supreme Court case of all time, because we don't really know what it's going to do yet. You know, it's a pretty substantial departure from the 5th Amendment, which was originally intended to act as a protection against weird takings, because you need just compensation for any takings that are for public use, the only type of valid takings. Another note is that even if the government does seize your property, compensation is not really ever just. You know, buying a new home, replacing an existing home, the amount the government gives you is always going to be lower than the value it would cost to have everything exactly the same. So, you're pretty much boned. In sum.
How do you
Is that a technical term?
Okay, so a brief summary of my case, even though you've already heard it once, you can hear it again. Sullivan, the plaintiff, sued the New York Times Company, the defendant, for defamation after they printed an advertisement raising money for civil rights at the Civil Rights Movement. Said advertisement was also aimed to pay Dr. Martin Luther King Jr.'s defense fees after he was arrested on the orders of Sullivan and other Alabama officials for trumped-up charges of perjury. The plaintiff claimed that he, as well as 3 other Montgomery officials, were defamed in a full-page advertisement. And the plaintiff saw this as an attack on himself and other officials, even though they were not named in the article. The article did contain falsified information, but the defendant, the New York Times Company itself, had no knowledge of the false information and just printed what they were paid to print. This case is immensely important for several reasons. First off, it protects one of our most basic inalienable rights. That's the right to free speech and freedom of the press, and even in some ways, freedom of assembly. It protected these basic rights as I can't remember the name of the committee. The committee that paid for the advertisement, they printed something that was not popular among a racist Southern government. The Southern courts agreed with them, and it showed that even through all this adversity, they were able to turn around the judgment in the Supreme Court 9-0. The case is immensely important for the civil rights movement in the 60s and protecting all of our inalienable rights of speech and press and freedom of assembly.
Okay, actually, New York Times v. Sullivan doesn't really have a whole lot to do with freedom of assembly because it was an advertisement printed in the paper. I don't know where that one comes from. But also, the important thing about that case is that it established that there has to be malicious intent for libel, which really isn't that relevant unless you're a public figure. Are any of you public figures? Yeah. No, you're all private citizens. Senator Inslee is, so it's important to him, but not really the rest of us so much. Basically, it's just everything that case established was just a corollary of freedom of the press, and Dr. King would have gotten out of jail anyway. That was bogus. But Kelo v. New London, on the other hand, is more important to all of us, being private citizens and being subject to government takings if the government so chooses. It's about protecting us, the little guy, from giant, omniscient, scary government thing that can take our homes, our property, our livelihoods out from under us. Important to note. What if you were a farmer? You'd have no more fields. Oh my God, you'd die. Thank you.
Okay, so Nicholas Summer writing freedom of assembly is not directly mentioned at all in my case, but it did affect the civil rights movement, which we utilize freedom of assembly quite often. And in protecting the civil rights movement from oppression via speech, it helped in that way as well. Nick made a point that my case is not important to regular people, and there's not much that we see that's relevant to us. But he also made the point that his case is important because we don't know what's happening. And we do know that my case did protect the right to free speech and the freedom of the press. We do know that it helped defend Martin Luther King, the greatest and most prominent leader of the civil rights movement. And we do know that it had a lot of prominent effects through trickle-down, if not directly. We don't know anything about what's going to happen from Nick's case, but for that reason, it's not important, at least not yet. And we're talking about the most important in history, in my case.